Hey, I'm back to talk to you about the ways that the federal courts have actually been very, very helpful to gun owners recently. And I'm going to talk about cases from both Texas and New Jersey. Okay? Now, Texas, we expect Texas to be pretty friendly to gun owners. New Jersey, a little bit more of a surprise, and we're going to talk about both. But before we dive in, if you have not yet hit that subscribe button, go ahead, hit subscribe, like, and share this content. That way, both you and your friends can see and learn about these pro-Second Amendment related issues. All right, let's start out by talking about New Jersey. In New Jersey, we're going to talk about a case that was brought by the National Shooting Sports Foundation, the NSSF. And the NSSF sued the state of New Jersey over Act 1765. Act 1765 was passed in 2022, so last year, and what it allowed the state of New Jersey to do, what they authorized with this act, was they authorized nuisance suits against firearm manufacturers that failed to take, quote, reasonable measures in connection with their importing, manufacturing, distribution, or marketing of firearms or firearms-related items. Okay, so when we talk about firearms-related items, they're expanding this to potentially go after manufacturers of accessories, manufacturers of ammunition, manufacturers of categories other than traditional firearms manufacturers. All right. Now, the reason they're doing this in the form of a nuisance suit is because federal law restricts many ways in which firearms manufacturers can be sued, and this is through the Protection of Lawful Commerce in Arms Act. Okay, the Protection of Lawful Commerce in Arms Act was designed to stop people suing firearms manufacturers when firearms are misused, firearms that they make. They can still be sued if they make a gun that blows up, if they make a gun that is essentially a poorly made firearm that malfunctions and hurts somebody. They can absolutely still be sued. It prevents them being sued when there is a misuse of their firearm. So somebody takes a gun, does something stupid, and murders their neighbor. They should not be able, the manufacturer, the importer, the seller should not be sued for that because of this Protection and Lawful Commerce in Arms Act. New Jersey tried to go around this by suing for nuisance when these firearms are used in a way that New Jersey says is not reasonable protections upon their importation, manufacturing, or distribution, and it allows lawsuits to proceed not only against the manufacturer, importer, distributor, or marketer, it also allows suit to proceed against any employee or agent. So now if you worked for a gun store or you worked for a marketer that was marketing firearms, you would also have to be nervous about being sued. So obviously, very, very detrimental for the firearms industry. And when the court looked at this, the district court in New Jersey, they said, no, this is actually preempted by the Protection and Lawful Commerce in Arms Act. This is not legal for New Jersey. And interestingly enough, New Jersey tried to argue this case by saying that there was no Article 3 standing. Now, Article 3 standing is a legal term. It's used by lawyers to define when there is actual harm that allows somebody to get before a judge and get relief. Okay, in this case, asking for injunctive relief. And New Jersey tried to argue that the harm to the manufacturers, importers, dealers, all of that was speculative because the people suing had not yet had this new law enforced against them. They said until it's actually been enforced against you, it's entirely speculative, and so they tried to keep it out of court by saying that there was not standing. Fortunately, the judge said there is standing, and in finding standing, he pointed out that New Jersey had actually created an entirely separate office in the Attorney General's office. They had created an entire office just to bring these suits. And so that meant that the Attorney General in New Jersey intended to bring so many of these suits against gun manufacturers, importers, distributors, or marketers that he created its own office within the Attorney General in order to bring these lawsuits. And so obviously this was not speculative or hypothetical injury that the NSSF was suing over. This was very, very real injury that was coming to the firearms industry in New Jersey. Thankfully, an injunction was issued to stop Act 1765. Okay, and what an ironic name, 1765. Why don't we talk about Act 1791 when the Bill of Rights was written? I think New Jersey ought to go check that. But That's the first case I wanted to talk about. The second case comes out of Texas, and this is the Fifth Circuit, again with another pro-gun decision. This is United States versus Rahimi. This involved certain protective orders. It's been a long-standing prohibition under 18 U.S.C. 922 that there are certain classifications, certain categories of people that are prohibited from possessing firearms. One of those is persons subject to protective orders. Now, the Fifth Circuit looked narrowly at only certain types of protective orders, but they said under the test as established by New York State Rifle and Pistol Association versus Brune, this is unconstitutional to prevent these people from possessing firearms. And again, this is another, maybe expected from the Fifth Circuit, but another huge win post-Brune that shows you can't just paint with a broad brush and ban all of these people from possessing firearms, because as we know, these laws have been misused over the years time and time again to restrict people's rights. And the Second Amendment's pretty clear on what it says shall not be infringed. And thankfully, with the power of Brune, we're starting to see more and more decisions that recognize what it says. If you like this content, hit subscribe. Go ahead, like this, share this, tell your friends about us. Until next time.